Hello, this is Hannah Tavik with the Week 7 case study. I chose to do case study number 8.5, which is Jackson versus the Birmingham Board of Education. So some facts on the case was that Roderick Jackson was hired by the Board of Education in Birmingham, Alabama in 1993 to serve as both the physical education teacher and the girls basketball coach. In August 1999, he was transferred from his original location to the local high school, which was Ensley High School. All of it was in the same district under the same Board of Education. And when he arrived at Ensley, he discovered that the girls' basketball team there was not receiving equal funding or access to uniforms, equipment, practice equipment, gym times, game times, all of that kind of stuff. And he finally said that with this limitation, it was making his job hard for him. So in December in the next year right after he started at Ensley High School, he decided to begin complaining to his supervisors about the inequality and not having access to what he needed to coach these girls correctly, but he had no luck with the administration trying to better the program. After he started complaining, in the months to come, he began receiving negative evaluations from the administration, and because of those evaluations, he was ultimately removed as the girls' basketball coach. So, arguments on the both sides of this case were that the plaintiff, Roderick Jackson, said that the Board of Education retaliated against him negatively, making him lose his job as the girls' head basketball coach because he had complained about the sex discrimination he was seeing in the high school's athletic program, and he believed that this was a violation of Title IX. But the defendant, the Birmingham Board of Education, they wanted to move to dismiss on the grounds that Title IX's private cause of action because it does not include claims of retaliation. The question in this case that needs to be answered is, does Title IX allow suits for retaliation for complaints about unlawful sex discrimination? This whole case is about the retaliation of the sex discrimination. That is what Jackson is fighting. Some things you need to know about the case are that in the beginning, the court did not award Jackson protection under Title IX because it did not provide the private right of action of retaliation. He would not be entitled to that relief because he's not within the class of persons protected by the statute, even though the amendment states that on the basis of sex, you can't be excluded from participation in, denied the benefits of, or subjected to discrimination under any educational program or activity receiving federal financial assistance. So they were saying that that Title IX did not say anything about retaliation. Yes, it covers the equality of men's versus women's sports and financial equipment, educational purposes, but it does not cover him as the person who was reporting the sex discrimination against the retaliation that the school had by firing him in his job. But further on in the case, they did determine that retaliation is discrimination because it is an intentional act. They were retaliating Jackson's job in response to the nature of the sex complaint. Because of his complaint, that is why they retaliated against him. And it was concluded that Title IX does prohibit retaliation. It might not explicitly state the terms of retaliation in the amendment, but on the basis of sex discrimination, that was in plain terms. The reasonings behind the court's findings were that in the 1970s, Sullivan versus Little Hunting Park created the need for Title IX, and in this case was that all citizens were protected if they spoke out against discrimination toward one of the tenants who suffered retaliation, which is on the same basis as the case Jackson versus Birmingham Board of Education. The retaliation's claims extend to those who discriminate against others, and that's why Title IX was created, to protect such practices. And there was such a need for this that Title IX was passed only 3 years after the court's decision of Sullivan versus Little Hunting Park Incorporated. So the court's decision was that They held that Title IX allowed suits alleging retaliation for reporting sex discrimination, and such retaliation constituted intentional discrimination on the basis of sex in the violation of Title IX. And in this court case, it was a 5-4 decision on the judges, so 5 agreed with Jackson, 4 did not, meaning that he was awarded the right under Title IX to pursue his claim in court against the Birmingham Board of Education. Implications for the athletic and activities administrator. So if there's a pattern of violations or issues under Title IX that are gender discrimination in the school, then if the administrator knew that, they should not leave that situation unhandled. It is their job to find a solution. And each institution, as an administrator, you should create and update Title IX policies. In this case, an example would be prohibition of sex discrimination and retaliation in all aspects of learning, including the classroom, athletic programs, and day-to-day campus life, refers to both the students and the teachers and the coaches. So if you think about it, if there's no protection for teachers and students from Title IX, then the teachers and the coaches would never speak out about this discrimination, leaving it unhandled. So, and also, the fault might not fall directly on the administration, so you might think that it's not your job to figure out a solution for the sex discrimination, but it will fall on the Board of Education, directly affecting you as teachers, coaches, and it will affect your athletes. And that was case study 8.5. Thank you.